Did you say at the beginning that extreme suffering is the essential standard here?
Yes, I think every court of appeals essentially has said persecution.
Is that a legal question, what extreme suffering means?
No, I think that's the kind of inquiry that's going to you look at the totality of the circumstances. I think it's kind of a concept that most people can grasp, and you're going to have to, in each case, just look at all of the facts and say, was this extreme enough? How much suffering was there here?
But I think that suggests that you really can never have cases that serve as precedents for others, or that the court is not actually developing law in the area. And that's my concern. I mean, I understand questions of fact that arise out of disputes over what happened. So if we had a situation, not this case, but if in this case there was some question about whether he was actually threatened, the government had some evidence that showed that what this person who was seeking asylum said happened to him wasn't true, all of those things would be questions of fact that the trier of fact would be charged with determining. But then once we have the established body of facts, you move to another stage, which is determining whether or not this body of facts meets a certain legal standard, whether it's persecution or some other standard in this area of the law. There are many legal standards in immigration law. And I guess I'm just concerned about the suggestion that in this second stage, where we have settled on the facts and we're deciding whether or not, or the agency has decided whether or not the legal standard is met, that we're somehow now in a world that is not a question of law.
So that's because, like this court has said several times, when there's a mixed question, it's not just the historical facts. It's what inferences you draw from them and how you weigh them. And that's traditionally the province of the jury, like this court said in TSC Industries, where the court said it's not proper to do summary judgment for the materiality question when, even if you take the historical facts, there's going to have to be inferences drawn and weighing. And the other thing I'll say is that it's not the case that the legal principles go totally undeveloped. I think that's totally belied by experience over decades. There are lots of times when courts of appeals, in the course of applying substantial evidence review, will either say, one, petitioner wins, so as a matter of law, no matter how you weigh this, then you have this rule of law. But also, in the course of saying that, they'll provide broad guideposts. Like, for example, in general, mere threats are usually not going to be enough.
Well, could